of the division bench order, page 3, Lordship. We accordingly direct the state to release all the area incentive stipend as directed by the learned single bench on the basis of the data uploaded by the respective DLDOs within 4 weeks from date. I beseech your lordship's kind attention to the report filed by the state respondent on the last occasion. Page 47.
Page 47.
Yeah.
Yeah.
Kindly come to serial number 1, Lordship, that is Devoprasad Dilip Chandra Kumar and no, my lord, page, not page 47. I'm coming.
47.
My lord, page 44. Kindly come to page 44, Lordship.
Yeah.
Okay,
My lord, petitioner number 1, Devdas Manna. But he got not a single penny, Lordship. Why he doesn't get not a single penny? I explain you to your Lordship. My lord, can you come to 1, 2, 3, 4, 5, 6, 7 row? My lord, AI point. His AI point is 2500. My lord, after getting 800 AI points, they are eligible to get the incentive, area incentive. Now they are coming with a plea that his standing point is 0. That is why he is not eligible. They write eligibility is 0. But nowhere in the single bench order, in the division bench order, nowhere it is written that they will not eligible after without getting any tagging point or only 800. If they score 800 points per month, they are eligible to get the incentive. But now they are come with a plea that they are not doing any tagging point. That is why they are not eligible. That person is the petitioner number 1 in the contempt application. He got 0 penny, Lordship, in spite of having rendering his service for last 20 years, Lordship.
This court has heard learned counsel for the parties and has considered the report filed by the alleged contemners. It appears that some petitioners have been paid and reasons have been attributed for non-payment or to some petitioners. Full stop. This court is of the view that the issue as regards entitlement and consequent non-payment can no longer be and the issue as regards the entitlement or otherwise and the non-payment can no longer be issued in the contempt application. The same may be agitated by the petitioners in an independent proceeding. Full stop. In view of the above, contempt application shall stand disposed of. The rule, if any, shall stand discharged. There shall be no orders to cost.
I was also thinking, my lord. In contempt application, your lordship cannot decide
that. I was trying to tell you to please stop so that I can say something. You went on and on and on and on. Why have you wasted your breath?
I told her, my lord. Morning, I told her.
The report is there. Copies are there with you. The reasons for non-payment is there. Fresh cause of action.
Your lordship, my lord, only record the liberty to challenge the.
I have already said that.
Deeply off.
My lord, in item number 5, I am appearing on behalf of the petitioner, my lord, led by Mr. Ujjwala. My lord, this is appearing for the first time, my lord. My lord's order is at page 19, my lord.
Who has not complied?
My lord, it is the West Bengal School Service Commission, my lord. Lord, Mr. Sodo Mitra was appearing.
Contempt is alleged with the order date 15 March 2024 by the School Service Commission. Full stop. Let notice be served of the contempt application on the alleged contemners. They may be represented through alleged contemners and Mr. Saurav Mitra, who represented the CSSC in the writ petition, Full stop, Mr. The contemners may be represented through learned advocate on the adjourned date. Full stop. Let appropriate instructions be obtained by Mr. Mitra in the matter. Grateful. Next Friday.
Service. Item 6, we are appearing for the petitioner. Pursuant to lawsuit directions of the last occasion, we appear before the district magistrate on Monday at 2 p.m. We have already done, my lord. Each and everything records regarding this legal air certificates to be issued by the magistrate. Now, the magistrate has already acted upon by the competent officers to inquire into the matter. So, my lord, if your lordship, my lord, will take up this matters on 1 week after, so that the compliance report of compliance will be filed by the state. And my lord, pursuant to the DI,
The collector has caused an inquiry.
first in inquiry.
It appears from the submissions of learned counsel for the petitioners that they duly appeared before the district magistrate collector Nadia on the 5th of Nadia and produced necessary documents. The DM, the collector Nadia
Inquiry report
has
report
asked for a report from the executive officer Navodip municipality. Full stop, paragraph. By by 15th July 2024, list this matter on 19th July. Next Friday. It is expected.
Supplementary affidavit, all records are already been relied before the magistrate. We have already admitted
That's
that.
part of non-necessary. Ask your collector to
Yes.
submit a report on that day.
Yes, only compliance.
The collector shall submit a report on the adjourned day. Collector Nadia.
My lord, I am appearing on behalf of the petitioner, my lord. Your lordship, it is a compassionate appointment. And my lord, on 20.
First time.
First. My lord, kindly see page 90. Page 90. And my lord, thereafter communication, page 21.
Contempt is alleged of the order dated 20th March 2024 by the commanding officer 55th Battalion, NCC Tomluk. Full stop, paragraph. Let notice of the application be served on the alleged contemners. And Mr. Shudeep Palit and Ms. Shayuni Roy Chaudhary, who represented them in the main writ petition.
Two
Full
containers.
stop. Full stop. That instruction, let the contemners may be represented through learned advocates. List the matter next Friday. Serve notice, please.
My lord, I am for the petitioner, my lord. First time, but they are appearing, my lord. This is
Only
against your
thing-
lordship's order dated 26th April, that consent order, that Malda DPSC 2009 selection process.
Milord, I tell you, Lordship, Milord, so far as the matter is concerned, the instruction says that an appeal had been preferred, and this has been mentioned by my learned junior. The matter will be taken up any day in the next week against the main order. Therefore, Miller, I am appearing. I am
Contempt is alleged to the order dated 30th
My lord, another
April
thing, my lord, and
2024.
another appeal was filed, dismissed.
It is submitted by Mr. P.S. Bhattacharya that the appeal is likely to be listed, taken up next week. List a matter on 26th July.
26 July, yes.
My lord, another appeal was preferred, that was dismissed.
Didn't you tell the appeal court? Why are you telling me?
My lord, only one thing, service of the competition may
That
be.
can be done. Yeah, it can be because it has.
Let copy the contempt application be handed over to Mr. P.S. Bhattacharya, learned senior, to the learned advocate and record for Mr. P.S. Bhattacharya, who is authorized to accept the same on behalf of the contemners, alleged contemners. Full stop. Formal issuance and service of rules dispensed.
My lord, I am for the petition in this matter. My lord, your lordship's mandatory order, my lord, is at page 21. My lord, 24th June 2024. Your lordship's directed the Commissioner of School Education to approve the panel, and thereafter the DPSC was directed to issue the appointment letter. And the petitioner service has been notionally.
Notice of the contempt, let notice of the contempt application be served on the alleged contemners and Mr. Bhaskar Prasad Boisho, who represented the DPSC, Purulia, and Mr. Supriya Chattopadhyay, who represented the state on in the writ petition, indicating that the matter shall be taken up next Friday. Let instructions be obtained. The contemners will be represented through learned advocates. Let instructions be obtained as to why the order is not being complied with. Full stop. Paragraph.
On next Friday, my lord.
I am for the petition. This is my contempt application. In the meantime, they have filed an application for recalling. Not recalling, for modification of some word. So they are
My lord, Mr. Shumon, they filed a recalling application and he is on the way, my lord. I'm paying for short passover.
They mentioned that I am entitled to get pension with effect from 3rd of October, 30th October 2003. Notionally, Lordship granted me from 1996. That is the difference. So if they have granted notionally from 30th of October 2000, I have no problem. But serving given immediately, a very long time already passed.
My lord, Shumon, they filed a recalling application. I'm not aware about this matter, my lord. I'm paying short
What do you
passover.
say?
Well, if you are allowed this application,
Mr. Dev wants to make submission
next Monday, well, kind of fixed on Monday.
Monday.
Monday. Both matter. Next matter will same.
Monday. So Monday হবে না? Friday, sir. Next Friday.
Yes, next Friday. Well, remain in the same position. Yes.
What did I put that? Yes. What do you say? We start? Take it up.
No, that's not it. Also, next Friday, next.
This is what we expect. I mean, this is what the younger generation must learn. Not to pull a fast one expert. He may be stuck for various reasons. unwell or stuck in traffic or not well. But I hope the newer generation learns, Mr. Bhatt.
But in some courts we find dismissal order is passed very quickly.
Even
I was arguing a matter before Justice Arun Mishra and Justice Jaimallo Bagchi. My matter was also dismissed because he was dismissing. Then I told the Chief Justice and Justice Jaimallo Bagchi, I know it is a court for dismissal, but you will have to hear me. Then I continue for 2 days.
my practice is yes, if the petitioner is not there repeatedly, I do dismiss, and old matters I don't spare. I will dismiss on the first day. But I have a policy and everybody knows about it. Restoration is a matter of course in this court. It will happen. No matter even delay of 1,000 days, whatever, I will restore. But I insist that the matter will be heard on that. That is all I insist. Because, Mr. Counsel, the problem is 80% of the pending litigation, if not 80, maybe 70%, people have lost interest in them.
Because
They no relief they got initially, or maybe the client went away.
clients do not.
Client is not contacting, so that it creates an artificial pendency which is fake. Real matters get affected. Real urgent matters that have to be listed and heard. Have to get-
come.
I'm very sorry,
It's all right. I had adjourned it, so my mood is gone in the matter.
I'm listening.
No, it doesn't happen that way. Next Friday.
Order has been passed already.
Get full lordship.
In fact, he was accommodating you. He was saying, I don't want to do it
I'm
next
like
Friday.
grateful, madam. Our beloved senior, my lord, I'm grateful.
Definitely. Next, please. 13, sir. Application নেই কেউ কি করা যাবে কি করবো এখন কোনো কারণে আটকে আছে আজ বৃষ্টি বৃষ্টি পড়ছে নট টুডে করো হ্যাঁ
What time for the petitioner, my lord?
yes sir where's the other side today you start we can't keep
Restoration
adjourning
application-
all matters like this
Restoration application.
restoration what is the main matter
Main matter, my lord, interest to get it, my lord.
interest and gratuity and nonsense sufficient grounds are available to explain the absence to the petitioner on 19 July 2017. Full stop. Sir, twice it was dismissed. I mean, twice you did not appear. Justice Banerjee dismissed it twice in 2017. Anyway, available to explain the absence of the petitioner on 19 July 2017. Full stop. The order is recalled. The petition is restored to its final number. List the matter under the heading Old Matters in the Old Matters next Thursday. What is the main matter? Pension benefit. Have you served as the affidavit of service? Notice of upgradation is there. Now দেখি notice of upgradation দেখো কবে service হয়েছে? "22nd. Where is the recent upgradation notice? Give notice of upgradation. No. We'll hear it out the same day. Why behind the back, sir? Next.
I am for the
I'm-
petitioner, my lord. For the
I am
applicant.
for the respondent number 125.
My lord, there is a recalling petition. Actually, kindly see the last judgment, my lord, of 28th November last. Actually, I have been directed to approach to the authority under Industrial Disputes Act, but this is not per as per statute, my lord. This is not as per statute because statute says otherwise. Section 2A of the Industrial Dispute Act, Section 2 capital A, my lord, kindly see, and then other sections.
So this is not a ground for recall.
Absolutely. That's why I'm saying.
And
On what ground can you seek recall?
recalling for restoration and modification.
Restoration.
Yes, my lord.
What order you want restored?
The order by which the writ application has been dismissed on the ground that writ court is not an appropriate forum. My learned client prayed before your lordship for regularization. Your lordship was kind enough, after considering everything, that it is a disputed question of fact. And your lordship was kind enough to relegate the entire thing under the Industrial Disputes Act and given a
My
liberty
lord,
to raise an industrial dispute for
my lord,
regularization.
it is totally wrong.
Writ court cannot
Totally
direct
wrong.
for
I
regularization.
object to it,
Is
and I give you plenty of and
So
from
there is
the-
something called procedure.
there is procedure.
What is the procedure?
Section 10A, Section 10 of the Industrial Disputes
What is
Act.
the procedure for challenging a wrong order?
No, I'm not
If an
challenging.
order
I'm
is
not
wrong,
challenging.
what you're saying is the order is wrong. You have a right to say that.
I am not challenging the order, my lord, here.
That's what you're saying.
I am recalling to restore the file
Definitely not.
and my
If you
lord,
are aggrieved by the order, you prefer an appeal.
appeal can be preferred, my lord, but if it is done at your level, my lord, then
Definitely
it
not.
will be best.
Recall of the order dated 28th November 2023 is sought on the ground that this court has committed error in law. Full stop. Paragraph. An application for recall of an order cannot be made on such ground within the meaning of the Civil Procedure Code or even the writ rules of the High Court. The writ rules of the High Court. Full stop. In those circumstances, can 1 of 2024 is dismissed? This na in those circumstances this court is surprised at the audacity, at the casual manner in which the application has been made in total disregard of procedural laws. Full stop. Paragraph. In those circumstances, can 1 of 2024 shall stand dismissed with costs assessed at rupees 3,500 payable to the respondents.
My lord, can it be considered Section 10? Not a single workman cannot go unless he is dismissed or discharged. Section 10.
EP. A single judge has a right to be wrong. Have you heard of that?
Yes.
Maybe I was wrong.
Yes.
Go in appeal. You can't file a review on that basis. You can't file a recall, much less recall.
My lord,
Order 47 is not there. Order 9 is not applicable.
my lord, 3,500 is the penalty for
Definitely,
a poor person.
poor person has a right to make this, will not take appropriate counsel and advice.
My lord, kindly consider.
Definitely not. The audacity of the person, sir. You come before the judge and have the audacity to tell him he is wrong.
It is an application for recalling and restoration and modification of
Sir,
the order. my lord.
educate the client first. Next,
Modification for the order was.
modification.
I informed my junior has went there to match.
What is the main matter? Have you served?
Main matter is relating to my lord. The petitioner said for the teachers recruitment examination 2012 and 2014 she appeared for the written examination 2021 and 22 first panel and second panel published. My academic qualification is very good. In spite of that, I was not appointed by call. That's why I made an I wrote a letter to the right to information.
Sufficient grounds are available to explain the absence of the petitioner on the 8th of June 2023. The order is recalled, the writ petition is restored to its final file and number. List the matter in the monthly list of August 2022. Court.
Well, I informed the other side. She asked me to send the notice in a WhatsApp. I have sent her. Mr. Saikal.
Inform her. Petitioner shall notify the respondents of this order.
I'm good.
18, not today. Call. Same, not today.
Petition, my lord, with the respondent file before the.
My lord, Mr. Chattopadhyay is appearing. He is engaged on court number 2.
Not today.
Not today, my lord.
I'm for the petition, my lord.
Yes, sir. Notice.
Yes, my lord, noted. I saved notice, my lord. I
When?
serve notice.
When?
Today, my lord.
You serve notice today?
No, I am serve on 10th, my lord.
10th.
Yes, my lord.
Go.
Affidavit of reply, my lord. My petitioner is a primary school teacher, my lord. He joined the school in 2013, my lord. Since he working, my lord, he made an application for A category space scale benefit, my lord. But same as not considered till now, my lord. Petitioner passed the Madhyamik from the school, Bihar School Board, my lord, and JBT also passed on Bihar, my lord. Page 24. I previously filed an application, my lord, as per order Honorable Justice Amrita Sinha, madam. Petitioner passes as an order.
না না, এটা অন্য দূরে আছে গো। 51
Is the NCT a party?
No, my Commissioner party.
Let the the affidavit in opposition filed by the respondent, number 2, Commissioner of School Education. No, in the affidavit in opposition filed by the respondent, number 2, it has been, it is stated that on behalf of the Commissioner of School Education that as to whether the teachers training school examination certificate after completion of training course during 1990-1992 from Bihar School of Examination Board,
Yes,
Patna,
sir, Patna. He has completed training cert reports 90 to 92, madam. And he passed.
is a valid training certificate recognized by them is required to be ascertained. In those circumstances, the regional director, Eastern Regional Committee, NCTE,
Madam, I am annex one document.
having his office at G7, Sector 10, Dwarka, New Delhi, 110075, be added as a party respondent to the instant proceeding. Full stop. What have you annexed?
Madam, as per reply, madam. Can you see, madam? Reply in 2012, madam. On notification, by this joint secretary. Para 1, my.
So D, NCT shall also indicate as to whether the petitioner's qualification would entitle her to A category pay scale. Qualification, comma, comma, would require any further training qualification or bridge course for the purpose of entitlement to A category pay scale. Full stop. Paragraph. Let amendment be carried out by an advocate in regard to the petitioner in course of the day. Let service be effected on the NCT of a copy of the writ service of the writ petition affidavit in opposition. Affidavit of the CSE and the replies of the petitioner be served on the NCT and affidavit to service be filed. List the matter Friday week.
I'm for the DPS.
Sir, affect the amendment.
Yes,
Yeah.
we shall.
Affect service file send everything to the NCT. Writ petition, the CSE's objection,
Yes.
and both your replies. Send it to NCT. File a comprehensive application. Ms. Gudguti appears to the NCT, is it?
I shall my lord get it confirmed.
Full stop. Service. Let a copy of the service be effected on the NCT bolam na through Miss Gudgutia, who normally represents them before this court.
Lordship, I am here for item 24. So I'm the senior counsel for NCT in Calcutta High Court. So they can, as it pleases Lordship, I'll accept that.
Madam, can you communicate your address to the writ petitioner, please? Please inform
Yes,
them.
Lordship. Yes, Lordship. It's 10 KS Rai Road, 10 Kiran Shankar Rai Road. Lordship, I will.
At 10 Kiran Shankar, is good.
Grateful, Lordship.
When come my Christian?
Friday week.
Friday week. Can you obtain instructions by next Friday?
Yes, Lordship. As soon as they give the pleadings, Lordship, I will certainly.
Today?
Yes.
Next Friday, koro eta.
Next Friday.
Next Friday.
এখানেই হয়ে যাবে তো?
Grateful, Lordship.
তোমার কি?
Next Friday.
Friday week.
Lord, there was a direction on 18th May 2023 for exchange of pleadings. Lord, we are at fault. Lord, I was seeking some extension.
Time to file affidavit. What is the interim order you're seeking?
I'm saying to a lot to let it both be kept back until disposal of the
What is the grievance, sir? Please.
petitioner with the diploma in education specialty. She was initially not allowed to participate in TET 2017, citing the reason that she did not.
Not a valid training qualification.
No, she did not have the 50% marks in higher secondary, but she possessed graduation. She moved to reputation for this honorable court and other institutional. This honorable court by an interim order directed the board to allow us to participate in 2017 on the basis of our graduation and diploma in special education. Now, I appeared in the TET, I qualified in the TET. Subsequently, 2022 recruitment course, I applied for the recruitment course. Upon the A has been issued in my favor. The interview letter has been issued in my favor. I went to the board for appearing in the interview. I was not allowed.
Because of special diploma and special education.
No,
Because
no.
of not having 50% in high secondary.
Scrutiny verification.
And diploma.
And under orders of court, you were asked. Yes.
Scrutiny verification stage, which is before the interview and aptitude test. In terms of the NCT notifications, 45 was the required percentage in senior secondary. It was detected she is having 43.9.
Yeah, but she appeared under orders of court.
No, orders of court in TET. This is for recruitment process. She is an eligible candidate.
Can you see the eligibility of the it specifically says graduation with diploma in elementary education, whatever name known. My case before your lordship and before the single bench also.
Graduation, there is no requirement of marks.
Because I'm graduate.
Show me the notification.
Number page 47, the first notification of the NCT.
Yes.
Number kindly see minimum qualification plus 1 to
Senior secondary 50%. Then senior secondary,
4 years bachelor in education. Keep over the
Page
48. Senior secondary or equivalent with at least 50% marks and 2 years diploma in education, special education.
Right.
This notification was subsequently amended. That is page 50. Relevant paragraph is page 52 in 2011.
Yes.
The class 1 to 5, senior secondary, kindly skip over third, fourth. Senior secondary or its equivalent with at least 50% mark and 2 years diploma in education, special education. Second, graduation and 2 years diploma in elementary education in by whatever name known. Our case before the honorable single bench, when we are allowed to participate in the TET, that a diploma in elementary education and diploma in education and special education is same and identical. And we referred and judgment of this honorable court, and we are allowed to participate in the TET. I participated in the TET, qualified in the TET.
TET has got nothing to do. It's a mere eligibility. Because you are allowed in TET, you don't have a right in a recruitment process.
In the recruitment process, what were the requirements?
My lord,
Page 52.
No, NCT guidelines dated 29 July 2011 clearly states that graduation and 2 years diploma in elementary education, that's DLED, are the eligibility qualification for primary school teachers.
Whatever name known.
Whereas the petitioner possesses graduation and D.Ed special. This D.Ed special and DLED are not the same, which are not the eligibility criteria as per NCT guidelines dated 29th July 2011. That's our stand. Good. Give us the shortest possible time. We will say this on affidavit and decides this.
Oh. Diploma in special education, in that earlier other matter, where I held that B.Ed in special education, diploma in special education should be the same.
Yes.
Jaivir Singh was
NIOS
I
DLED.
cited, I said that insofar as Jaivir Singh is concerned, Devesh Sharma is concerned, B.Ed versus DELT, that analogy, distinction and analogy would not be applied to diploma in special education and B.Ed in special education.
Correct.
That was the issue there.
Correct.
And repeatedly it was placed before this court that diploma in special education is a qualification for teaching especially able children or whatever.
Yes, yes.
In the primary level.
Yes.
1 to 4, 1 to 5.
1 to 5.
If that is the RCI guideline based on which the NCT and as per the MOU and all with them, why shouldn't it be applied in
Because
this
this
case?
is D-Ed special, not DL-Ed. This is not elementary education.
The requirement is DLED.
No,
DLED.
she's having D-Ed special, diploma in education.
That's right. That is the for special education. That is the only qualification.
Requirement is diploma in elementary education because the teacher will go and impart lessons to 1 to 5.
The RCI guidelines say, which has been adopted by NCT, that diploma in special education is a qualification enough for teaching special children of class 1 to 5. That is the RCI guideline.
That is diploma in
That is what is being stressed by the council on that day. You yourself.
subject to correction, my lord. It was DL-Ed within bracket special, not D-Ed special.
No, absolutely not. It was diploma in special education.
My lord, may I check up and come back?
Please check and come back. You
Very
can come back today also. This can be disposed of because it was diploma in special education and B.Ed special education. That were the two categories. It was specifically a diploma as opposed to diploma in elementary education, which is DLED. Both are diplomas. So this is a diploma special education. And that is exactly what the RCI had said. You want to come back, you want to check it, I'll just pass it over. We can dispose it
Not
off.
today because I missed my spectacles.
Dear me. That's a problem. That's a serious problem.
One more thing, in case of
Mr. Banerjee, I think if you are satisfied, please indicate to the court. Let this matter stand and be listed on Monday or Tuesday. Tuesday. And a heading to be mentioned. This can be disposed for an affidavit.
One more thing, if the DL special education and DLD will be the different.
1 minute.
Here preach course.
1 minute. 1 minute. Yes, madam.
My lord, I am not aware whether NCT is made party in this case, lordship.
No, I don't think the NCT is it a party?
No, my
No. NCT is not a party, madam.
Lordship.
You were a party in that matter.
Lordship, yeah, I was there, lordship. And direction for affidavits is given by lordship, and interim protection was given to the petitioner on the basis of the observation made by lordship today also, lordship.
I'm getting the impression, Miss Gudgutia, that I will never have the privilege of seeing you physically.
No, lordship. I seek indulgence only for a few times. From Monday, I'll be there, lordship. Because of some personal traveling issues, I could not be there. I'll be there on Monday, lordship.
I can
I'm grateful, lordship.
much of it.
Yes,
For the fiction, I'm really grateful. After a long time, the matter has come.
finally.
Unfortunately, but fact is that long ago, I have served a copy that is 2011, 2023. So there is no scope of interim order. So my
Hello, I am appearing on behalf of the DPSC North Chobis Forum, my lord. I have no copy, my lord.
I shall give the copy.
I shall take instruction, my lord.
In the meantime, my humble prayer before officer kindly give him direction to file report. Then the matter.
Yes.
What is the grievance, madam?
That is, I was selected in the 2015 on the basis of
Lordship, in this matter, lordship, I seek indulgence to appear for NCT, lordship. NCT is a party. Grateful, lordship.
They have advised me to join in the provisional. I went there, but in the meantime, chairman depend me from the 15 lakhs from me. That's why I lost the complaint. Thereafter, I came before the court. On the basis of the court's order, I have joined. So the 3 years, 10 to 13, why should I deprive? It is not my fault. I was selected. Why they will not?
You joined. You are working.
I have joined. That is 2013. Thereafter, number of representation has been made. Even I have already made a demand. Just
Others have joined with effect from
2010.
10.
Because I was in the panel.
NCT is not a party here.
NCT আছে দরকার নেই তো তখন at that time NCT was 2003.
2006.
The petitioner
Selection process
has joined the post of assistant teacher with the DPSC Which DPSC?
Not so.
Not 24, not 24 Parganas. In the year 2013, pursuant to orders of this court passed in WP 13675 2013. The writ petitioner
Court already observed that I was selected. Can you say page 32?
1 minute. Order dated 16/5 huh? 16/5 full stop paragraph. The petitioner service has commenced from 14 January 2013. So the petitioner claims that she was already selected since 2000 in 2010.
Yes.
And has been wrongfully deprived. Her service must be reckoned from the year 2010.
Okay.
Full stop. The petitioner appears to have approached this court immediately after joining. Immediately after joining in the year 2013 itself. Full stop. When did the others join? 2010?
Take instruction. Yes.
Because
2010. Then she is entitled to serve.
my name
I
was
will file a report, my lord.
You want to file a report?
name was in the panel.
I take instruction, my lord.
Complaint page 26.
But
What are the
state
instructions?
election process? My lord, thereafter petitioner came before this honorable court.
That's
Pass an order, my lord.
No. Sir, I have allowed a lot of writ petitions like this. You want to still file a report?
Yes, yes, my lord. I take instruction, my lord.
As you like.
There is really no need, Mr. Counsel, because she is in time. She came the same year as she had joined. I have dismissed applications where they came 9 years later.
Take instruction, my lord. No,
Your man is here, take instructions.
from the day. We have Amina Khatum.
Very well. But I think the petitioner has made out a case. Full stop, the DPSC. Not 24, not 24 Parganas.
Yes, ma'am.
Full stop. She'll file a report in the matter, list the matter next Friday
Okay. This is my address.
at the top.
Don't really give it.
I have allowed writ petitions yesterday itself.
Yes, my lord.
I have dismissed 3 writ petitions yesterday because they came late. One came 1 year before retirement, one came after retirement. I am having a shortfall of 4 years and 3 years. But in this case, she joined in 2013 and she have filed a writ petition in 2013 itself. This writ petition.
Yes.
First one as well as second one. So she is within time.
Madam, I am appealing for the petition. This matter presents with compassionate upon. Petitioner's wife died of chronic disease. In the year 2006, petitioner made authority consider and rejected on the ground that petitioner is 45 years, 3 months old. 45 is cut off here. After that, hearing this writ petition, I did not challenge that. But there is a GO government order which I annexed here. There, the principal secretary of the education department has the power to condone the age limit.
Where is the impugned order?
Impugned order is
25th July 2022, my lord.
Page?
Page, but a region order, my lord, can it?
Oh, it is not annexed?
No, yes, my lord, they have page 25, 6, my lord. They have annexed in the petition, page 26.
26 is an order of this court.
Yes, but then region order passed by the
when page
chairman
28,
district family
this
school
order
council.
passed page 20.
Yeah.
It is not a government school, it is a government added school, my lord. Kindly see the page 3, my lord. Cost title of the page 3, my lord. 3 primary school, my lord. Nivedita Vidyapit, 3 primary school.
What is this geo dated so and so? 57 SE? Dated 15 January 2002?
In that June, 45 years has been scheduled as
Upper age, my lord.
Upper age. You're 45 years, 3 months old.
My lord,
The
he's
geo
now
on which I am
48
relying
years,
upon,
my lord.
I'm just coming. The geo on which I am relying upon, that is at page 29.
1 minute.
And the relevant part is at page 31, C. Page 31, C. May I read?
Yes, this is
Labor Department. Only the principal secretary has the power.
only ground of rejection was 3 excess age.
Yes, my lord. My lord,
Otherwise, he is entitled to.
not only that, my lord, but also, my lord, I am praying that it is not the government school, it is a
That is not
non-aided
the,
school, my lord.
that is not the ground taken in the rejection order.
My lord, kindly see, my lord, page 30, my lord. The government employees for the purpose of this scheme means a government employees appointed on regular basis and not the one working on daily wage or casual apprentice and ad hoc or contract or re-employment basis.
He is a full-time employee,
My lord,
but it
but
is not
is
a government aided.
employees, my lord.
It is not a government school, it's just an aided school.
My lord,
Aided school.
But that is not the ground you have taken in the rejection order.
my lord. Not only
Rejection
that,
order, it is only the age factor. You have not said that you are not entitled to compassionate employment because you are not a government employee.
yes, that's not a ground.
That is not the ground
I am
taken.
taking this point, my lord. It is not a government school, my lord. It is
Sir,
non-government.
your DPSC feels it's a government school.
His wife is getting the pension, my lord. Who will get
Not quite. That's right.
twice
Pension
benefit?
is right.
Will not give, my lord. Twice benefit.
He is getting pension on account of his wife.
Yes.
That is right.
The writ petitioner is agreed by order dated 12th December 2022
But kindly give me opportunity to file the opposition, my lord. Or report, my lord.
by the chairman DPSC South 24 Pargana. By the impugned order, the application prayer for compassionate employment on account of the death of his wife, who was a teacher in Nivedita Vidyapit FP school. Pre-primary schools are
Yes,
not
Non-government,
government schools.
Non-government.
Sir, your DPSC didn't take that point in the
Yes.
impugned order.
It is wrongfully done, my lord. Probably, my
Full stop. কি বললাম? Was rejected on the ground that the petitioner was aged above 45 years and therefore not entitled to compassionate employment appointment in terms of GO 57-SE in bracket primary dated 15 January 2002 as amended by GO 418-SE dated 11th May 2004. Full stop. Paragraph. Counsel to the petitioner submits that in terms of the rules for compassionate employment dated 3rd December 2013 published by the Labour Department of the Government of West Bengal, the authority concerned, the appointing authority has power to condone 3 months of excess age for the said purpose. Paragraph. Counsel for the DPSC, you're for the DPSC or the state?
My lord, state, my lord. State.
However, submits that the DPSC in the instant, DPSC South 24 Parganas has made a fundamental error in the impugned order. It is submitted that the petitioner's wife was an employee of an aided school and hence not a government employee within the meaning of the scheme for compassionate employment in the state. Full stop. The petitioner was not entitled to any compassionate employment at all. Let a report be filed by the state. You are DI or SI?
My lord, state DI and SI also, my lord.
Then the DI of schools PE.
State of West Bengal.
South 24 Parganas file a report on the matter by way of affidavit. Full stop.
My obligation.
Admittedly, the petitioner is receiving pension on account of his wife's service. Right, actually.
My lord.
List the matter Friday week.
No, Friday, I have sorry, my lord, difficult, my lord.
Friday week.
My lord. সপ্তাহ সময় লিখো। My obligation.
Sir, you have a difficulty there. You may not be entitled to any employment at all. The DPSC has been, I mean, he have just put blinkers on his eyes.
There is one single point. So far as my inference of this matter is concerned, that is where the aided circulars as regard aided school is silent. Silent.
So your wife is not a government employee.
No,
There are a lot of schools here, minority, otherwise Christian, whose teachers get DA, right? That constitutes an aided school. So DA getting schools, one category, aided schools, non-aided, there are several categories. They are not government schools. Government schools, compassionate employment, if you are a government employee. So you are not a government employee, your wife, that is.
My point is different. My point is this, that if the circular is silent about the special, under the special statute, the...
Sir, you argued. You take an exception. Sir, you file the report, sir, give him an advance copy so that he can take an exception. Argued, sir, whatever it is worth, definitely. But your DPSC South 24 Parganas, your chairman, please tell him, pass correct orders.
My lord.
Next.
27. The 27, my lord, I have got the petition. Well, this is my petition.
Track report, আছে? Yes, sir.
My lord, Arindam Chakraborty is appearing on behalf of the DPSC Council.
Order of Rule 7 of Sub of West Bengal Primary education conduct of service teachers in primary school 2001 is.
Virus challenge.
No, no, not right. The order. My lord, the petition was working as a. On October 28, 2022, the FI was registered under POXO Act. Subsequently, on 29th of October, he was arrested. Thereafter, on November, an order was passed by the appointing authority under Section of Rule 7 of the
Deemed suspension.
My lord, the petitioner was enlarged on bail on March 1, 2024.
2 years is in custody.
2 years. Thereafter, my lord, he made presentation in the month of April. Presentation that was not considered clear. My lord, this now he has filed the petition challenging this order on the ground of. My lord, till the criminal court held him guilty, the presumption of innocence still in the favor of the. Till late, no departmental proceeding has been. The alleged
Has the incident occurred in respect of a school, child of a school?
No, the alleged incident was committed outside of the school. So, my lord, this continuation of the suspension is tantamount to an punishment. So, therefore, my lord, this representation of page 26 that was still not being considered.
Consider the representation.
My lord, DPSC,
You consider and dispose it of.
Yes.
Thing is, I am concerned about one thing. When the offense is under POXO
Yes.
and he's a primary teacher, I can understand your apprehension. Normally, any offense done outside the scope of the school service, I have asked you to revoke suspension and because you're paying him provisional pension and provisional this
My
substance
lord,
allowance. It's a loss to the state. But in this case, it's a POXO offense.
My lord, Section 6 of the POSCO Act, my lord, detained in jail custody more than 1 year.
Well, if you look.
I am aware of that, madam. But you take a decision in the matter.
Okay.
The petitioner has agreed that his representation dated
May 16, 2020.
18th May 2024 has not been considered by the chairman DPSC. Which place? Nodia. So the petitioner was in custody for 2 years in connection with offences under Section 6 of the POXO Act. No, Section 6, 8 and 12 of the POXO Act. Full stop. He was suspended from service immediately after his detention under section after his detention for more than 48 hours, in terms of the order of the DPSC dated 19th April 2024. No.
November 20.
After hearing this.
November
28.
28th November 2024.
2022.
2022. Full stop. Paragraph. The petitioner submits that since the incident in quest alleged against him is pending trial, did not arise out of his service in the school, he is entitled to be reinstated after revocation of suspension. The school has also not started in disciplinary proceedings against him. In view of the above, this court directs the chairman DPSC Nadia to consider the petitioner's representation and dispose of the same in accordance with law within a period of 8 weeks from date of communication of copy. From date of receipt of a copy. Sorry. Only thing that bothers me is an offense under POXO.
Since the ingredients of Section 6 is not available, that is only reason the petitioner was returned.
The petitioner argues that in the order granting him bail under Section 439 of the CRPC, it a writer will. The High Court was pleased to observe that ingredients of section 6
Page 22.
are not available.
No, not. Whether the ingredients of section 6 of POXO Act is proved has to be determined in the light of the associate evidence during trial. The paragraph starting, we have considered the materials on record. Victim has been examined. She has stated that the petitioner has touched such and such. Whether the ingredients of section 6 of POXO Act is proved has to be determined in the light of the associate evidence during trial.
My lord, come to page 18, my lord.
Now, whether as to observe that as to whether
My lord,
the ingredients of section 6 are established against the petitioner is required to be ascertained only in course of trial.
my lord, kindly, extremely, my lord, come to page 18, my lord.
Read it out.
My lord, Office of the Order District from District Primary School Council. My lord, last portion, last line. He shall be paid subsistence allowances as per rules. All cons.
He's getting substance. He's not disputing that. I am agreed by this. I am concerned only by the fact that you're paying him 50% salary. For what?
Yes.
It's a drainage to the state's funds, isn't it? He is not rendering any service. Sitting at home, he's getting 50% salary like pension.
Yes.
Take a decision.
Yes, my lord.
But if you find him, I mean, there are so many other factors. Like he has had some allegations in the school also, but they were not investigated or whatever, nothing reported. Then all those your DPSC chairman will know. In that case, is a danger. Then you initiate disciplinary proceedings and terminate him.
Yes,
Next.
My lord, page 37 of the petition is result is NC, not NC. Result is supposed there NC.
NCO.
NC.
NC.
Not certified.
My lord, I am
That
appearing on
means
your
the
page.
petitioner failed to obtain the 50% marks of HS.
Yes, Mr. Bari.
Category scale pay this argument wrong. They consider it allowed the category scale of pay from the year of 1922, 2022. Last date of examination is 20.
And petitioner
Entitlement has been decided. Initially, what has happened?
When did you join service?
I joined the service.
Seventeen. 17. You didn't have 50% marks in higher secondary.
Yes, everything was there. There was examination.
One mark sheet, Obisek Day, page 37, my lord.
NC is not completed. They have taken a decision that some withheld was there, NC was there. Thereafter, it has been withdrawn. Certificate was given. Everything will be clear if your lordship kindly have a look at this. They are later.
Page 37. Where is NC?
My lord, last.
NC, not certified due to not filling eligibility criteria, 50% marks. To be done after verification.
And my lord, page 32.
Now, your lordship kindly have a look, page.
Senior secondary school examination manager, page 32. Result.
Result triple X.
Cross. And all
DEF.
Result.
How did you recruit him? Oh, this is NIOS.
NIOS.
Now, your lordship kindly everything will be clear. If your lordship kindly have a look, page 56 and 57. That was pending. The issue was there. They declared pass. No problem. And
NIOS 40.
This is the training qualification. It is not
40.
Page 56. Page 56 and 57.
Did you pass the where is it?
That's why I was drawing the Lordship's kind attention.
Page?
Page 56 and 57. the Lordship's kind.
Yes, yeah, they are saying go to the website and find out.
Yeah.
Where is the website extract that you passed?
The pass certificate.
Yes.
No, they have pass certificate and they allow it starts from page 42 onwards up to 50.
42.
42 onwards up to 50. A category scale.
No, that they have given.
Yes, 2 years pass. The LED course has been accepted by this office. It has indicated its job. Otherwise, a paid candidate cannot be allowed to give the benefit of the primary itself and the state authority. You also got it. Page 42 top.
Where is your client's name? Dheeraj Kumar Singh.
Dheeraj Kumar Singh.
Where is he?
Dheeraj Kumar Singh in the next page 44.
That's all right, but where is your certificate of passing? Where is your certificate of DLED?
Certificate of the
It's available on the website. You should have downloaded it.
page 38.
38.
38 is the certificate. One certificate has been annexed. If you lordships want to.
Definitely, we want to know.
Yes, my lord.
We want to know whether you have passed the certificate
Yes,
course or
my lord, that day one copy I have
38.
given. One copy I have given. If your lordships.
This is Arun Kumar Day.
Arun Kumar Day.
How many petitioners are there?
No, nine petitioners are there. 10 petitioners there. We have.
Arun Kumar Day is not a party in
Is
this.
not, yes, my lord.
No, this certified.
Apur Day.
This is Abhishek Day. Abhishek Day, sir. Abhishek Day. Past 17, 19 DLED. Where is the other qualifications of all the people?
All the people have not annexed.
Why not, sir?
Because I have made a categorical statement. If it is required,
No.
I can produce before your lordships.
Please produce.
Very well, no problem.
Leave is granted to the petitioner
Yes.
file supplementary affidavit indicating as
Annexing
to
the-
whether each of the petitioners have passed the DLED course, 2-year DLED course, 2-year DLED course conducted by the NIOS. Through through NIOS mode. Full stop. Where's court fees, Mr. Court fees? आगे लगे evidence of payment of court fees is kept to the record. Supplementary affidavit. Full stop. What are you aggrieved by?
Because of the fact they have given a category scale of pay from the 2022. Your lordships have said it is the last date of grant. That is the only one I have given that. This is the, if there is a doubt, I am the last person to.
No. Maybe your client is misleading. We don't know. You know clients better than anybody else, Mr. Bari.
That is true.
Better you have the document on record.
100%. Your lordships keep it on Tuesday, by Monday. Submit.
Tuesday? Yes, what a Firudda.
Before right, 31 again I have been requested by Mr. Moscow. Not
Not today. 31 not today. Inform the other side.
Yes, no, other side has informed us.
Oh. Yes. For 2 minutes. So where your matter is being called. Please ascertain the convenience of some place which is convenient for all of you.
Here, not including my.
No, I can't see at the back.
That's not.
Any side should be fine.
Every court.
I think every court.
Any side or front side of your lordship.
Not so convenient, more so for the lawyers. A side should be better so that any side. ওরা একটা সাইডে লাগা
Opposite of entry.
ওই কোথায় মামলা ডাক হবে না হবে এগুলো তো ওরা জানবে না আমাদের কি আমরা তো লিস্ট লিখে যাবো
I pay for WBBP.
Yes, sir.
3 times I appeared to the teacher eligibility case. First time on 2016, which was the selection point of 2014. Second time on 2020.
Other way around. TET 2014, then TET 2017.
16.
No, 16 there was no TET.
17. And then
20 and 23.
Let I tell you, Lordship. 3 TETs, 2014, 2017, 2022. 3 selection processes. 3 selection processes, 2016, 2020, and 2022.
Selection was of 2022. Result published in the year of 2023.
Right.
Why not I 3 times my marks allocated in the interview were near about 1 and 1.5.
On page টা?
Thereafter, I made an article.
On page
I have got that knowledge from that out of writing. But my recommendation was too good. I was not a candidate to get on the minimum. So I only pay.
Score in the Viva interview.
Only interview.
Only interview.
Only interview. So I am paying.
Your TET score can be brilliant. No problem. But interview, it is consistently bad. Which means you can't blame them.
Yeah, I am only seeking. Why I have come here, madam. I am only seeking for all for the videography because now it is a system to make transparency of the interview to make videography of.
Sir, there cannot be. The law is for interview marks, which is the subjective part. Least marks are allotted. Maximum marks are for academic, TET, eligibility test, aptitude test. Maximum marks. Subjectivity, Supreme Court guidelines. Subjective, on least marks. I think 10 or 5. 10. If you are getting 1.
1 and 1 subject. So that is
1 minute. So the subjective element, there can never be an appeal on a subjective matter. A writ court does not go into subjectivity. The very nature of the interview is a subjective satisfaction of the persons. There cannot be any appeal on that. There cannot be a challenge to that.
I am paying so much. I didn't have that got the opportunity until unless there is a provision of. Since there is a
Sir, I have heard of re-evaluation of in a OMR sheet, answer scripts, but I've never ever come across re-evaluation of in a Viva marks. In my career, I have not come across because the law is against you. The law says subjectivity, exclusive discretion.
That's true.
So why can't sit in appeal over a discretionary matter?
Election process and for better transparency of the.
The petitioner seeks the videography of the interview conducted by the WBBPE, interview stroke Viva voce, for the year, for the recruitment process of the year 2022.
Then it would review my marks.
Full stop. The full stop. He submits that he participated in two earlier recruitment processes conducted in the year 2016 and 2019. 20. In which he was awarded 1 and 1.5 marks each. It is submitted that given the petitioner's performance in the TET academic qualifications and aptitude test, it is impossible that the petitioner should get 1 and 1.5 marks in a Viva voce exam. Full stop. Para. By dicta laid down by the Supreme Court, marks in a Viva voce, which is the subjective, a Viva voce market that. It is now well settled that a Viva voce stroke interview marks are based on the subjective satisfaction of the interview panel, of the members of the interview panel. Full stop. To eliminate any chance of subjectivity playing any vital role in any selection process in the country, in terms of the dicta of the Supreme Court, the least of marks are reserved in any examination process for the interview part, which is the subjective part. Paragraph. The very nature and categorization of interview marks being subjective, the question of any review under Article 226 of such subjectivity does not and cannot arise. In the aforesaid circumstances, the question of calling for any videography of the interview process of the writ petition of the year 2022 does not and cannot arise. For the reasons stated hereby, no relief can be granted to the petitioner. WP fails and hereby dismissed.
Actually, there was a disparity. The person who got lower marks in written examination, those person got higher marks in violence.
Quite possible.
That due to that reason, my lord, I have come.
Quite possible. People may be very not so good in answering questions, but they may be really brilliant in orally. Sometimes people it's a psychological thing. So some people are very good at writing, but when they can't face an interview, and that's vital because you will be facing students.
My submission was not whether my performance before the interview board was satisfactory or
That their marks
that was videographed by the
that can't be judged by a third party, much lesser it court. Absolutely not. We have no area to role to play in that because it is subjective. It is completely discretionary.
Not only one correction in the second last line. It should be 2022 recruitment process instead of 2023.
22 crore. The law says that subjective matters absolutely outside the domain of any appeal, any review, any challenge, any questioning.
recruitment process of 2020 and examination held 2020.
Exam could be interview held in 2023. Next.
Lordship may recall Mr. Subir Sanyal yesterday mentioned this matter. He will be visiting his daughter.
Yes.
My Lord, I was praying, may this matter be listed next Friday, my Lord.
Next Friday. Next Friday? Next Friday.
I'm for the state law.
Similar moment.
Proportional benefit appointed in 2023. I gave representation. Now the facts matter. 2006 election process. Appointments made in 2010. I was external, I was not given. I filed a petition in 2013. In 2013, my lord, the coordinate bench directed me to give appointment. Thereafter, not appointment given, contempt filed, administrative issue. In 2023, I was given.
When did you challenge representation?
In representation. Representation, my lord, I have given.
Is it a repetition of 24?
It's a after 1 month, immediately after joining my lord, I gave a representation in protect from 2010 when other persons were appointed.
What about the earlier order?
My lord.
What?
Order of justice. What is
21?
No. First order is in 2030. Page 21. 2015 was the order.
40.
The Ashwadikari's order at page 21. Order was to recommend and get necessary approval by the school commissioner of school. Thereafter, they did not comply. I file a contempt appeal.
Yeah. Controversial justice.
Yes, sir. At least you should get it from 2013, if not 2010. 2013 is the date of filing of this writ petition.
তুমি বলবেন আমি বলবো
For the state.
আমি for the state, my lord. My lord, it is my lord.
23 you give the
My lord, your lordship kindly, the joining report. The joining report, it is at page, my lord, 33. One joining report from 27 also. There are several petitioners there. My lord, in the joining reports, my lord, is 33 also one of the joining report, my lord. They have joined, my lord, without raising any objection, my lord.
No, could have been, but if you raised objection, you won't allow them to join. All of them. 5. No. 3. How many petitioners? 5 petitioners. All joined on the same day.
Yes, my lord. Approval letter on the same date, same writ petition, contempt application, they were given the order on the same date.
Only notional, no financial.
I don't
Yes.
No financial benefit.
only know.
Notional. All increments, everything notional. But last drawn, the pay slip will be calculating notionally all increments. Nothing will be, no arrears, nothing will be paid. But current pay will be as equivalent to those who joined, let's say in 2013.
My lord, let me come with my lord, report, my lord.
Sir, I have.
If your lordship, sir,
Can you improve upon this? What report can you give? Tell me. Can you give any other report? The facts are all here. Justice Dashodikari's order, contempt, everything, this, that. Dispose it off.
From 2013, I have no.
The writ petitioners challenge.
writ
Petitioners.
authority.
5 WP 12713 of 2013
appointment দিচ্ছ appointment দিয়েছে court order
being aggrieved by
কোনো কথা হলো objection করো
non-consideration of being aggrieved by the fact that they were not appointed despite succeeding in the recruitment process of the year 2011. 6. That was concluded. That was conducted afresh in the year 2011.
2006 election process completed in 2010.
That was completed in the year 2010. 2006, 2010. Paragraph. The petitioner, by an order dated 20th April 2015, a single bench of this court in the said WP number 12713 W of 2009 directed appointment letters to be given to the petitioners.
অর্ডারটা কখন দিতে হয়েছে 2013 থেকে নোশন ডিপেন্ড
The respondents did not comply with the same.
না 2013 অর্ডার হয়েছিল
And contempt proceedings were initiated. The petitioners were thereafter issued letters of appointment in August, on 23rd August 2023. Petitioners joined service
জয়েন করতে 2013 তে বলেছিল
on the same day.
2013
No, on the 28th of August 2023.
তখন নোশন
23. The petitioners claim that they are entitled to
contempt ইস্যু হয়েছে এই কন্টেম্পটের অনুযায়ী দিয়ে দিয়েছে
কোথা থেকে দিয়েছে নোশন
কৃষ্ণ রাও অর্ডার রিসিভ
since they were entitled to appointment
নোশনাল বেনিফিট তো দেয়নি
in the year
কোনো এরিয়ার কিছু
2010 itself.
না আমি একটা অবজেকশন দিয়েছিলাম
their appointment 2010 itself. The respondents
এখন কি নোশনাল বেনিফিটের জন্য
ought to be directed to treat their ought to be directed to give effect to the appointment with effect from 2010.
2013 my lord order was passed.
Full stop. Paragraph. Having regard to the facts and circumstances of the case, this court is of the view that the delay in issuing letters of appointment to the petitioner cannot be attributed to them. Full stop. The matter full stop. It is the fault of the DPSC concerned DPSC and the state in delaying issuance of their letters of appointment. So
No,
in that
actually,
view of the
DPSC is the
matter-
one of the appointing authority.
State
State will do.
In that view of the matter, this court directs that the service of each of the writ petitioners shall be reckoned from the
What are
day
the
from when did you file the writ petition in 2013?
Exact date.
Exact rough date, month.
এই যে বলে দিচ্ছি এই দেখো 4 5 জন 5
I'll direct it, sir.
February 25.
In February, in March with effect from March 2013, i.e. when WP 12713W of 2013 was filed. Full stop. Paragraph. The petitioners shall be petitioner's service. The service of the petitioner shall deem to commence notionally from 31st March 2013. Full stop. They shall not be entitled to any financial benefits from 31st March 2013 till 28th March 28th
29th August 1 Piyali Shah joined.
From until 28th August 2023. Full stop. Paragraph. The petitioners shall, however, the salary and allowances of the petitioners, shall be notionally revised from time to time based on all increments and ropas from 31st March 2013 until 28th August 2023. The salary and pay slips shall be recalculated and revised accordingly. Any arrears payable to the petitioner from 28th March 2023 till date shall be made available to them within a period of 2 months from date. The pay slip shall also be the pay slips shall be revised, notionally revised, based on the above within a period of 1 month. Full stop. The length of service, it is as a matter of abundant caution, it is clarified that the length of service of the petitioner shall deem to commence from 31st March 2013.
One thing I have checked from the records, the Calcutta High Court records, the sheet of filing of the writ petition is April 26, 20.
যেখানে এপ্রিল মার্চ 31st বলেছি ওটা 30th এপ্রিল কর ভাই 1st May করে দাও 1st May.
But national benefit 2030 only for the pay scale, ROPA
and annual increments.
Increment, only for ROPA.
Only that, and that too notionally calculated, payment prospective.
But here, Lordship, on the salary, Lordship, I think, Lordship, one
salary from 28th August 2023 till date. Okay, for that day arrears they will get.
Yes, any area 2023.
Because pay slip will be revised.
Among the petitioners point, there are 53-54. For that, the length of service for retail benefit at least 10 years qualifying service, I would have. That may be.
Sir, I have
already passed the order.
I said abundant caution, length of service shall commence from
2030.
1st May 2013. So they all covered. They'll get salary. They get pension.
Let's see, petitioner stamp duty paid, Lords. How many? That Lordship cited, Lordship.
No, show it to him.
There are
Take a printout, sir, and file it.
File it.
Course of the day. Evidence of payment of stamp duty has been shown to court. The same shall be, hard copy of the same shall be filed in course of the day.
Lords. Otherwise, you're not effective, Lords. Yes, otherwise not filed, then
Obviously,
there is a lordship
then it's a
usual
loss
order.
to the state government.
Yes. If the usual order is a lordship, if they are not paid, that lordship not affected.
I don't agree. You will have 150 petitioners and you will not pay stamp duty.
Yes, but the benefit has been given all the lords.
That is why they will also pay the.
No, no, it is 5 petitions. 5, we should know the.
150 only, that I am objection here, Lord.
No, I'm seeing.
No,
And they argue. No, same benefit.
Yes.
What nonsense.
That Lord.
The state is bearing the expenditure of all the infrastructure,
Yes,
salaries of all these people.
না 41 গুলো হচ্ছে না
এটা কত হয়েছে?
আমি যাচ্ছি।
Yes, sir.
The petitioner was appointed as a primary teacher in 1992. Whereas he was appointed as headmaster.
এটা কোনটা হচ্ছে?
47 তুমি কে ইন্দ্রজিৎ ঘোষ নাম দিয়ে দিও কাউন্সিলর কে আছে কাউন্সিলর লোক কত
On 14 December 2022. Well, after release of bail, he had been suspended. Obviously, because of the but he had not been the substance. In spite of all, rare is only for release of substance.
Yes, sir.
Lord, I am for the state, Milord.
Substance allowance he should get.
Milord, but Milord, the drawing and disbursing authorities, Milord, the council.
He's at the council party.
Council not. The
Howrah
petitioner
District Primary School Council
was suspended.
So,
but Milord, only one thing, Milord, in connection with his address, your lordship kindly comes to page 23 of the writ application, Milord.
Yes, please.
Maybe, Milord, the council actually has got no address to communicate because
And that's what you do his account.
no, unless
Why the address is required? He's up.
The school will have the address.
Still, he is in the school. He has not.
left without address and door locked.
That is his
Page 23. Page 23.
Sir, he is.
That is the set that his suspension order was sent to his residential address. He is still an employee of the school.
No. He must have been in prison that time.
Whether
One.
DPSC Howrah has been served or not, I don't.
Dagu, DPSC Howrah service hoita.
And even in the petition, his address is not mentioned in page 26, made before the DPSC.
Residing at village and PO Akui. In village, there are 10-15 houses. Everybody knows the other person's house, sir.
Where he is still an employee of the school. He has not been terminated.
You ask the postmaster in the village, he will know. A man in the village, he will know everybody's name and house.
And Milord, may I submit my report, Milord? It states that the also DPSC.
Petitioner has agreed that petitioner was suspended from service.
POXO Act.
Only the subsistence alone.
He is accused under section 8 and 10 of the POXO Act, Milord.
Treated on
He was suspension.
It's in page 23.
24. That is the order of suspension on 23/11/2023.
on 23rd November 2023 for being in custody in connection with Nishinda PS case number 213 of 2023 dated 2nd November 2023 under section 8 and 10 of the POXO Act. 8 and 10 of the POXO Act. Full stop. The petitioner claims that he has not been paid any subsistence allowance since after his suspension. Full stop. The state is represented and has filed instructions. Addresses to
Indicating that, Milord, DPSC Howrah is the concerned authority, Milord.
Instructions
for disbursement of
dated
his
14th May
salary.
24 addressed to state advocate, which is kept to the record. Since the liability of paying substance allowance and salaries is with the DPSC concerned. This co-
So I don't know whether it is served, but because your code officer said that it has been served, Lordship. But I don't know what is in the report.
Paragraph. This court directs the chairman DPSC, Howrah, to release all substance allowance to the petitioner, including arrears if not already paid. Mandatorily with effect from November 2023, 23rd November 2023, within a period of 1 month from date of receipt of a copy of this order, into his bank account within a period of 1 month from the receipt of copy of this order.
Admissible amount.
The current substance allowance shall continue to be released as long as the petitioner remains on suspension. Full stop. The chairman DPSC Howrah shall be at liberty to suo motu review the order of suspension in terms of the applicable rules.
Lordship, admissible dues, not any other. That
Only substance allowance. What other dues will pay him?
Lordship,
Nothing else.
if not already,
Unless already paid.
Lordship, my appointment should be regularized because I have not received.
All right. Let the name of Mr.
Kaushik Chaudhary.
Kaushik
Chaudhary.
Chaudhary, who normally represents the DPSC Howrah, is directed to represent it in this matter. Full stop. His appointment shall be regularized by the DPSC concerned. Grateful.
The DPSC Howrah has been directed to release the
all arrears of subsistence and current subsistence, if not already paid.
Gratefulness.
And you review the suspension. 8 and 10 of the POXO Act, trial may take, I don't know when. You are paying him, keeping him at home, you are paying him pension for what? Take a service. I mean, consider the fact whether it arose out of the school service or not, then it's a risk for the children.
My lord.
Okay, but consider all factors, ask your DPSC chairman to review the whole matter. There is no point in paying subsistence allowance for years together. Trial will go on. He'll sit at home, get half salary.
He'll be enjoying the money.
He'll be enjoying. You take his service. If he does something once, another act.
That's why the review part has been directed.
Suppose he commits another act within the school, then the question of then you can dismiss him from service also. Then we'll uphold that.
People are usually apprehensive. Apprehensive because 8 and 10 of the POXO Act.
Could be, but at the same breath, there are hundreds of false cases filed. POXO cases, POXO 498A has been so misused in this country. Politics and enmity with neighbors, this, that, and POXO is the most lethal thing. Straight away arrest, no bail, conditions are very NDPS next.
Next NDPS.
Oh my goodness.
Grateful, my
Well, I'm appealing for the state respondent. Is it whether
very good. Not good.
Not very county, Howrah and
48.
And also south, but we are Supreme Court passed the order.
With regard to
Regards to the appointment of
that I have directed.
No.
North,
south, Malda and Howrah. Here south, but here also the matter was hard before it not in the length of argument going. One and over Supreme Court passed the order of status quo on the division bench passed the order. That the vacancy. So also matter will release the lawsuit. But not then lawsuit only for not here.
next week.
Okay.
Only for the south.
Let us see. I'm for the board, Lordship. Lordship, there was a direction to file a report, Lordship. I'm filing it today and I'm handing over a copy to my learned friend, Lordship. I've handed over the copy.
Next Friday. Report filed by the
West Bengal
board in court by the board is kept to the record. Will stop. Let the petitioner time to file exception thereto is extended. Nah, the petitioner may file an extension there, exception thereto.
Borrow.
Within a week from date, list the matter Friday week. Friday week.
Friday week. Great. আমাদের
Son of AIDS. Not the age of the hospital AIDS. July 1969, but it has been recorded as July 1968.
When was it recorded?
My lord, it was recorded in the year 1977.
And
Admission register.
and when did you apply for correction?
Yes, my lord. The headmaster's forwarded decree.
When did you apply?
2011. Yes, 22.
77 it was entered.
Was recorded as
Wrongly recorded.
Register of the high school.
And 2011.
11.
77. You retired or you were working that time?
In the meantime, he completed his course and got appointment also. In 2011, the headmaster of the concerned school.
Were you working in 2011?
No.
Retired?
No, I am working.
2011.
No. I got appointment in the year 1990. 1995.
95.
Page 16.
95. What is your 55 years? You're due to retire in 58 or 60?
60.
5 years before retirement you come.
Western board is the lots.
So give them further copy.
But here, Lordship, as for the circular and the Supreme Court order, if you join 1995, within 5 years, you rectified. Otherwise, as per the rules and as per the ruling of the Supreme Court, it is not. Within 5 years.
File a report, sir. So you let them file a report.
Board is directed to file a report.
The petitioner seeks rectification of the date of birth in the service records of the school. In the year, full stop, the petitioner entered service in the year 1995. His date of birth as per the records produced was, what is the date of birth recorded?
Page 13 and page 13 and 12. Page 13, my lord. Date of admission 13/12/1977. Left side. Date of admission. Serial number, column number 2.
It was recorded as 30th December 1977.
And the date of birth has been recorded in the column number 10. Page 12. 1st July 1969.
কালকে 5টা 5:30 এদিকে
No, it is 77 ticket is up. Has been recorded as. What is the date of birth recorded? 2010?
Date of birth will be 1st July 1969. And it has been recorded in the documents, my lord, 1968.
14 June 1968.
68 in the documents, my lord, the secondary examination and service records.
Which 1968? Which day?
1st July.
Where is 1st July? 1st July 1969. That is Mohammad Gargis Ahmad. Signature of the father of Gargis. Okay, huh. As 1st July 1969. The petitioner submits that his date of birth actually ought to be না আগেটা লেখো recorded in the records of the school as 1st July 1968. ঠিক আছে? His date of birth as per the attendance register of his school is 1st July 1969. Full stop. Where are the school records?
Is 14.
School, not your school. The school in which you are working.
Admission registered is a page 12 and 13.
So this is the admission register at the school here you went.
Yes, ma'am.
You studied.
Yes.
Where is the admission, the records of the school where you are working?
Page 16. This is my appointment letter. 1670.
Where is your date of birth?
Page 21 is the service book. Page 21. This service book, it starts from page 19. Page
68.
68, left side.
That's as per your Madhyamik certificate. আগে 68 যেখানে বলছি as per his Madhyamik certificate. School certificate. Full stop. Paragraph. Counsel for the DPSC and the state and the board oppose the prayer for rectification. It is submitted that the rectification of date of birth must be made within 5 years. Within 5 years, and that too in a prescribed format. The petitioner has not done so. Full stop. Paragraph. Let the board as well as the DPSC file a report in the matter within by next Friday.
That's it, Kylie.
By Friday week, when the matter shall be listed again. Let advance copy of the report be served on the petitioner. Namdida.
I'm for the DPSC Howrah Lordship.
The subject matter of challenge of this one, that I have been working in a school as teacher, under the physically handicapped. But after the retirement of the headmistress of the school, I was appointed as the teacher in charge. My legitimate expectancy was that I may be appointed as a head teacher. Because thereafter that advertisement was given I applied for that. I have been working there. I have been challenging election policy, but it has been done in a very irrelevant and illegal manner. I'm not asking for the writ of quo warranto to that the person who has been appointed. That should be not made clear. My subject of the dispute is with regard to the selection process, and it has not been properly done. And that I agree because I cannot sit silent since I agree, and I feel that I have been deprived of the opportunity.
Were you put in the panel of head teachers?
Panel was there. I was the sixth in the panel.
Sixth.
I was
And the person appointed was
first
one.
And it was his appointment was given a day before the fixed date interview. A day before the interview. And then person can appreciate. Suppose it date is first week on court. And he was already appointed on court. And other candidates were not interviewed, neither they were called. This is
The petitioner is aggrieved.
Lordship, kindly come to page 32 once. See the qualification of the petitioner, Lordship.
Yes.
DLED NIOS.
No, that time it was allowed, no?
Lordship, that time allowed, but at the time of promotions, those as these orders has already come.
And he must be getting A category pay scale
Lordship,
also.
she's a teacher from
He gets
2017.
Obviously, he's entitled to be employed.
Lordship, there is a representation of the petitioner. Let that be sent back to the page 24, Lordship.
You want representation to be considered? Oh, definitely.
People at a time.
The petitioner is aggrieved by the process of selection of head teacher to the which school is this?
She is Vikram Vidyalay Branch Day Primary School. Vikram Vidyalay. You can, Lordship, into page 24 representation, second para it is written, Lordship.
Vikram Vidyalay branch, primary section.
To the
page 24.
Vikram Vidyalay branch Day Primary School. Sir, how did you work as teacher in charge until 2027?
No, I think, Lordship, she has the age because this is a appointment under died in harness. Her husband died, if I'm not wrong, and she got the job.
Full stop. The petitioner claims that
oh, Chilit. Oh, Ramesh.
The procedure for that that he was teacher in charge of the school for a substantial period of time and had also applied for the post of head teacher. The petitioner was empaneled in order of seniority as the sixth in serial number 6 at serial number 6. Well, so the private respondent, is he there? Party?
Party, I have not made it a party.
But the private, head teacher appointed is not a party respondent to the instant proceeding. Be that as it may, without prejudice to the rights and contentions of the appointed head teacher, let the representation of the petitioner dated 1st September 2023 at annexure P5 to the writ petition be. Why should, sir, where is the representation? This is not a representation.
This is a request letter, Lordship.
How can this be entertained when the head teacher is already appointed?
Lordship, subject to correction in the first line, Lordship has mentioned she was working as a teacher in charge. She was working as a teacher, but she requested to be a teacher in charge, Lordship. She was working as a assistant teacher, Lordship. He was working as a assistant teacher, not as a teacher in
Allow
charge,
my role as teacher in charge,
Lordship.
which means he was working as teacher in charge.
She was not officially a teacher in charge, Lordship. Maybe she was the senior teacher in the school and she was taking the responsibilities of the.
That is all. Teacher in charge is never a permanent post.
No, no, no.
The senior most teacher, because of the vacancy,
responsibility.
retirement,
Lordship.
she is given teacher in charge.
Lordship.
Thereafter, head teacher is regularly appointed
Lordship,
as per
Lordship.
process.
Lordship.
Ki bolla?
Sorry, sir.
All the time you are see.
No, Kirda, let the representative. The petitioner may make a formal representation to the chairman DPSC, Howrah, agitating his grievances as regards the selection process within a period of 7 days from date. Upon receipt of the representation, the chairman DPSC Howrah shall consider the petitioner's representation and dispose of the same in accordance with law within a period of 1 month thereafter. Disposal.
Communicate করতে হবে 12 তারিখ না
Not today, God.
Ram for the board.
Not today.
Not today. My lord, instead of my lord, Monday, my lord, kindly keep it on 16th, my lord.
16th, God. 16th. Tell him.
Full, my lord.
Tell
I will inform. 16th, the lord. I'm grateful.
Let this matter go out to the list with liberty to mention.
brief কথা
With me.
54 টাইম কেন না
আমি বলছিলাম
brief
Sorry.
go out of the distance.
Let this matter stand adjourned and be listed after disposal of the pending proceeding before the Honorable Supreme Court. Huh? No. Let this matter go out the list with liberty to mention after disposal of the pending proceedings before the Honorable Supreme Court. Out of the list with liberty to mention.
Lord, this is pending in the Supreme Court. He's wanting 6 marks, which is stayed by the Supreme Court.
I said out of the list with liberty to mention, sir.
Lord, after disposal of the Supreme Court proceeding.
After disposal of the proceedings for the Supreme Court. ঠিক আছে?
আমি তো
The state responding.
But I am appealing for the petitioner, Lord. The petitioner lost it, Lord. He is a primary teacher, assistant teacher in a primary school. Now, Lord, he has completed, Lord, diploma in elementary education. Now, Lord, the problem is that in his service book, it has been recorded on and from the date of publication of the result. And Lord, my Lord, own view is this, Lord, that on and from the date of completion of the course, his seniority has to be counted.
Have you corrected the order? Dida. Where is the order?
My Lord's order is not in another matter. That
Very well. That's that. Where is the impugn order denying A category pay scale?
I have submitted it presentation, no answer to that.
Where is your representation?
Kindly come to me, Lord, Annex 10, Lord, P11 at page 40.
I have the instruction, my lord, the as per the government, my lord, circular dated, my lord, 4th of March 2013. Your lordship also knows that, my lord, after the, my lord, language is after attainment of such qualification DLED. My lord, attainment means after completion.
Decided doesn't say.
Yes, my lord, I have, my lord, I was party of that, my lord, Tapun Haldar case.
Petitioner obtained DLED
In
qualification. The petitioner is an in-service teacher in the school since
Lord, he was appointed, I'm giving it. That is around 20th July 2000.
26 July 2000.
26 July 2000.
26 July.
The petitioner underwent the DLED course for the session 2007, for the year 2017-2019. The results of the course were published in the year 21.
No, my lord, June 19.
June to results June 19.
Yes.
Result are to pore.
And examination declared on 31st December 2019. Kindly have a look my the instruction. It third paragraph. Diploma elementary course of the session 17-18 was completed.
I have annexed it at page 33, my lord. Kindly see.
When were the results declared?
Lord, that is December 31st, 2019.
Yes, final result declared on 31st December 2019.
And my lord, the score, well, course completed, my lord, in the month of May.
June. My lord, there is some 3 or 4 months. Yes.
The conclusion Yes, sir.
Now, my lord, the examination was completed, reports was completed on June 30, 2019, and the result was published, my lord, on December 31st, 2019. They, my lord, have given me the effect on and from 1st January 2020. My request is, my lord, that my effect should be given from 1st July 20. 6 months.
The petitioner is an in-service teacher, has been working since
July 26, 20.
July 2000 under the DPSC Paschim Bardhaman.
Paschim Bardhaman.
Full stop. Paragraph. He underwent the DLED course for the year 2017-19. The last date of examination whereof was on 30th June
2019.
2019. Full stop. The results were declared of the course were declared on 31st December 2019. He has been allowed A category pay scale since 1st January 2020. The petitioner claims that the same is illegal and he should have been given A category pay scale from 1st July 2019. Paragraph. It is now well settled that the delay in publication of a result cannot be attributed, cannot be by the authorities cannot impose any penalty on the petitioner. In those circumstances, the petitioner shall therefore be entitled to, by this petitioner, since the petitioner has successfully completed the DLED course, he shall be entitled to A category pay scale from 1st July 2019. Full stop. Let arrears of pay to the petitioner between 1st July 2019 till 1st January 2020 be paid to him, being the difference between the normal pay scale and the A category pay scale, be paid to him within a period of 1 month from date of communication of a copy of this order.
That will be done by the respondent
By
number
the,
5.
by the respondent number 5, DPSC, Paschim Bardhaman. Writ petition is allowed and disposed of.
Next matter, my lord, is the same. Only thing, my lord, it is DPSC Purva Bardhaman. Same batch teacher, but date of joining service may be different. I am giving your lordship that yet.
Joint service on blank?
On, my lord, March 2005.
March 2005. Baki shop same. It a DPSC?
It is DPSC Purva Bardhaman. Acha, it affidavit of service. This is the affidavit of service.
Affidavit of service, do to think.
58 57.
59. For the board lordship.
The matter relates to recruitment process of 2020. Petitioner appeared in the recruitment process as the OBCB candidate. He succeeded. His name appeared in the additional panel of 5% additional panel. Now, after publication of panel, along with the marks of the petitioner in the panel itself, it is found that the while calculating the TET score of the petitioner, there is a small defect, small mistake of point 0.081. Due to such mistake, I have been placed in additional penalty, or I ought to have been in Mentament.
But
That is the
OBCA, OBCB, all certificates cancelled, sir.
But your lordship has protected our right in the last paragraph of the order.
If you have already been in service or availed the benefit.
I avail the benefit.
You avail the benefit when you get the service.
But I'm already in panel.
No, not in service.
Not
I'm
in
in panel.
service.
Your lordship
Panel.
Your lordship protected
Not
my right. I have
appointment letter has not been issued.
I have gone through this
Lordship
judgment.
was there, the appointment letter was not.
If
I
you
have
are
gone through this judgment, and I've gone through the last 3 lines of your lordship's observation. I've protected by your
no, sir. If you have got an appointment,
Now, your lordship has said if an
avail the
person appeared
benefit.
in the selection process, that not be disputed. I have the copy.
very well produce it. I don't remember. If you have participated,
Kindly, Mr. Biswas is leading me, Lordship. Today is not in court, Lordship. He has asked me to accommodate for 1 day, Lordship. Let
Very
me
well.
take instruction
Monday,
whether how calculation.
I'm very much protected by your lordship.
then it's okay. If you are protected, well and good.
I have gone through Amol Chandra Das. What my lord is saying is right. What my learned friend is saying is incorrect.
Please place it, both of you. Because I don't remember. Once I deliver judgment, I become mentally functus official also. It's impossible. Otherwise, you go mad.
The state has filed an SLP, but it
Yes,
is yet
yes.
to be listed.
60.
And for the petitioner, my lord, I am led by Mr. Rameshwar Sinha. My lord, praying for an ought today.
Not today.
I'm for the state, my lord.
Why don't you take this opportunity to make a submission? What is the matter? Are you aware of the facts?
No, my lord, I have not been instructed about the matter.
You should read the brief.
Grateful, my lord.
Never lose these opportunities.
$61.
One lordship, I beg to appear on behalf of the petitions and for the state. Well, this is the case relating to the 2009 recruitment process. My lord, petitioner has appeared. Whether my lord he has been qualified or not, that has been disclosed in the website. He made a 6-1 of the RTI Act. That was not decided. This is my lord the case.
2009 recruitment process.
2014 my lord examination was held.
I have allowed in up to what was the cutoff date?
Cutoff date March 2014, May 2014, 2009.
In that case, Kakoli Mondal.
Kakoli Mondal, that is my lord, I am very.
Kakoli Mondal cutoff date was 30th March.
31st March, Lordship.
31st March. This is filed in April.
April.
So, first, you don't get benefit of Kakoli Mondal. First things first. Secondly, this writ petition of 2009.
Nine.
Writ petitioner challenges his
Howrah.
participation in the recruitment process of the year 2009 in the year 2024.
Not there.
Full stop. Paragraph. The writ petition.
Kakuli Mondal is of North Howrah, not 24 Pargana. Kakuli Mondal. South is
So
Sourabh.
this is Howrah. This is Howrah.
This is Howrah and Sourabh Noskar.
Sourabh Noskar what was
Lordship,
the cutoff date?
Lordship. 31st March.
He does not get the benefit of. No, since the writ petition has been filed on 15th April 2024, the petitioner does not get the benefit of the decision of the case of Sourabh Noskar versus State of West Bengal and others.
Lordship, WPA 3268 of 2015. Order date 9 March 2024. 9th and 12th. 2 orders are there.
9th and 12th March 2024. Full stop. Paragraph. In any event, the writ petition is hopelessly barred by delay and laches, and it is inappropriate for this court to reopen A. Recruitment process of the year 2009, the year 2024. Full stop. No relief can therefore be granted to the petitioner. WP Phillips since hereby dismissed.
Lordship, my appointment may be regular because I have not.
Mr. So and so.
Kaushik Chaudhary.
Kaushik Chaudhary, is requested to represent the West Bengal Board of Secondary Education in this matter.
DPSC Howrah.
DPSC Howrah in this matter. The chairman DPSC shall regularize his appointment.
Murder. I have the copy of your lordship judgment. May I read the relevant paragraph? It's the last paragraph. The services of citizens from the 77 classes and 37 classes added in the exercise of section 16, struck down above, who are already in the service of the state or have already availed the benefit of reservation or have succeeded in any selection process in the state shall not be affected by the reason of this.
You've succeeded?
Yes, I'm in the panel.
Additional panel.
Yeah, additional panel is the panel. It's not the. It's not. I'm not out of panel.
Anyway, come Monday because Mr. Biswas wants.
Another paragraph is while carrying the above exercise, the commission did not revise the result of all those candidates whose names were included in the select list earlier published. We having already pointed out that the appointments shall not be affected by this exercise. There is no necessity to revise their result. Thus, this exercise shall be undertaken excluding all the candidates who are included in the select list. I'm very much covered by your lordship.
62.
My lord, 62. I appeal for the petitioner, my lord. My lord, compassionate appointment, my lord. Father died. Their application was made in the year 2021, which is at page 21, my lord. Let that be considered in accordance with law by the DI. Subject to what my learned friend says.
This is my instruction.
Application.
My lord, application page 21 in the prescribed format, annexed P7. Date, my lord, application dated 20 August 2021.
At that point,
at the bottom, 22, page 22 at the bottom.
At that point of time,
2021.
2021, not 1921, my lord, 2021.
He died on 14th September.
14 September
Just
2019.
1 month, short of 2 years.
Yes, ma'am. You logically come to page 21. At that point of time, he was filed an application. Man, his age was 17 years, 6 months.
Could not have applied.
17 years, 6 months. 18 years is the 18 to 45. And the 2 years. As and when he was going to an 18 years, the 2 years gone, my lord.
Only you applied, nobody else.
No, my lord, only I applied, my lord, because I am the only one who has passed Madhyamik examination in the family.
The petitioner's father died on 14th September 2019. He applied for compassionate employment on
20th August 2021.
2021.
Not August, my lord, it is
July.
July,
my lord, not August.
July.
20th July 2021.
2021. When he was 17 years, 6
months, 13 days
old. And 13 days old. He therefore could not maintain an application for compassionate employment. Full stop. Paragraph. The petitioner now by the time he attained 18 years of service, 18 years of age, being the minimum age for application, the period of 2 years has been crossed. Full stop. Paragraph. As on date, therefore, the immediacy of financial stringency cannot be deemed to continue. Full stop. The petitioner's family is receiving pension. In those circumstances, the claim for compassionate employment of the petitioner cannot be entertained. Reference in this regard is made to the decision of the Supreme Court in the case of State of West Bengal versus Debobroto Tiwari and others reported in so and so for 2023 live law, particularly paragraph 7 thereof. Writ petition is therefore disposed of without any orders. Sir, there is one provision that I saw of keeping people in a live register and things like that, like the CIL and Coal India Limited. Now, in case that provision is there, then you ought to have done it. But today in 2024, after 2021, that provision is not. So for future purposes, sir, once you make an application immediately and they say you are below 18 years, there is a provision of keeping you in what is called a live register.
Live. By the time,
because you are in the live register, by the time you're 18, you made your application within time. You are on the live register. Then you can be considered for whatever post. And in the meantime, you complete your DLED and all those TET instructions of the DPS, the DI, Uttar Dinajpur is kept to the record.
Get.
Okay.
Sixty-three, I am for the petitioner.
My lord, it is a 2009 recruitment process pending in Supreme Court, like item 55.
Let this matter go out to the list with the liberty to mention until disposal of the pending proceedings before the Supreme Court. What Niyogi is that?
No, Arindam Mandal.
Pending proceedings in the Supreme Court. That's it. With liberty to mention. पेंशन नहीं हियरिंग আসতে হবে তিনটে তো উঠতেই হবে আমার
Law will be taking hearing today.
কি করা যাবে old matter ডেকে দাও but then old matters it's half an hour before rising so I can't
Subject to correction.
কোনটা let's call the old matters then because I'll be rising in any event there's no point in calling old matters today call no point in calling hearing matters today
one indulgence, my lord, item 65, which my lord is the list that is going on, my lord, 65, my lord, I am seeking 7 days time because my lord, I just got.
So 65 won't be called today.
Yes.
Transfer matters on Monday only.
Monday.
And pension Wednesday.
Yes, my lord, because I need some time because I just got the brief and.
You will automatically get time, sir.
Yes, yes.
So, Akshu Barudak. Dismissed. 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 Dismissed.
Wonderful, my lord. On behalf of state, my lord, I'm paying for not to.
Krishna,
No, my lord.
respondent. Dismissed. Give your name. Dismissed. 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 Yes.
When I came running for my lord, item number 163, my lord.
163?
State, my lord.
You're for the state?
No, my lord, I'm for the
Krishna, old matters is out. Old hearing.
163.
All right, no problem. আর কেউ যদি আসে, হ্যাঁ, ওগুলো old hearing এ দিয়ে দাও।
No more matters today.
No more matters. ফাইল গুলো যদি ওখানে পাঠিয়ে দিয়েছো আমার এখানে তো দিয়ে দাও। হ্যাঁ? বলে বলে।